In 2013, it was a late afternoon. The tar road was shimmering in the heat. On the busy road of Madhya Pradesh, scooters and rickshaws zipped between cars. At the corner, a mason named Dhanraj was walking with a bag slung over his shoulder. Dhanraj was going about his life as a skilled maestri, earning a decent living for himself and his family. He's got some agricultural land too, adding to his income. Life's steady, predictable. And then it happens. In an instant, everything changes. The sound of twisted metal filled the air. Dhanraj was thrown to the ground with his body immobile. Moments ago, he was walking, now he lies staring at the sky, unable to move. That was the moment his world changed forever. The accident left him alive but broken. A medical board later certified it clearly 100% permanent disability. For the next 11 agonizing years, Dhanraj lived, but in chains, trapped in a body that refused to heal. No work, no freedom, no independence. Yet he decided one thing: if his body couldn't fight, the law would fight for him. So began his case before the Motor Accidents Claims Tribunal under Section 166 of the Motor Vehicles Act. The tribunal initially believed his income prior to accident was 8,000 rupees per month as a mason and from farm earnings. Therefore, they awarded him 18.52 lakh rupees with 9% interest as compensation. But Dhanraj wasn't satisfied. He appealed, saying this wasn't justice for what he had truly lost. The appeal leads to a remand. That's when a higher court sends the case back to the tribunal for reconsideration. The High Court remanded the case for reconsideration. But shockingly, instead of increasing his income, the tribunal slashed it down to 4,030 rupees. Think of it, from a skilled mason with farmland. The court now valued him barely above a coolie. His lawyers pointed out in Ramachandrappa versus Royal Sundaram, 2011. The Supreme Court had already said that even a daily wage laborer back in 2004 should be assumed to earn 4,500 rupees per month. By 2013, how could a mason earn only 4,030 rupees? The logic was flawed, and so Dhanraj L's fight reached the Supreme Court. But destiny played its cruelest card. On 24th April 2024, before the court could decide, Dhanraj died. 11 long years of life drained in a vegetative state. His family mourned, and the insurance company saw an opportunity. Their lawyers rose with a technical objection. The claimant is dead. Compensation for personal injury ends with death. Under Section 306 of the Indian Succession Act 1925, his legal heirs cannot continue. They quoted previous decisions, Bhagwati vs. Bablu, 2007, and Saroj Sharma vs. State of UP, 2014. It seemed like the case, just like the man, would end here. The tension builds. Will the appeal survive? The Supreme Court gets deeper. They look at the Motor Vehicles Act 1988, especially Section 166. And here's the game changer, a recent amendment by Parliament. Act 32 of 2019 inserted subsection 5 to Section 166, effective from April 1st, 2022. A game-changing provision came into force. Section 166 of 5 declared the right to claim compensation for injury shall, upon the death of the injured, survive to his legal representatives, irrespective of whether death is connected to the injury or not. That meant death didn't kill justice. The heirs could fight on. The case lived because the law now said his rights survived. The Supreme Court quoted from earlier cases like Oriental Insurance versus Jasmail Singh Kahlon, 2022, and Meena versus Prayagraj, 2025. Their logic was powerful. If heirs can claim in cases of death compensation, why deny them when it's lost to a state in an injury claim? The claim money, had it been awarded in Dhanraj's lifetime, would already have been his estate. And his estate is what his heirs were entitled to. The judges brushed aside the insurer's objection. The fight would continue, and justice would be calculated. So, how much was finally due? The Supreme Court scrutinizes. No docs for salary or agricultural income, but oral evidence from the shop owner. Monthly income fixed, 9,000 rupees. Add 25% for future prospects, 11,250 rupees per month. Multiplier reduced to 11 years, not 14, because he lived 11 years after the accident. Formula 9,000 rupees into 12 into 125% into 11 equals to 14 lakh 85,000 rupees plus already calculated heads, compensation for pain, suffering, medical care, attendant, nourishment, transport, 5 lakh 52,095 rupees, total 20 lakh 37,095 rupees, and interest 9%. But not only till 2016, as the High Court had wrongly capped it. The Supreme Court ordered from the date of filing till the actual payment. Finally, the insurer was directed to clear dues within 3 months. And that is how, on 26th September 2025, the Supreme Court of India delivered justice. A man who had lived 11 years locked in pain never got to see this day. But his family did. His heirs received not only money but a legacy, proof that a man's right to justice can outlive him. This was Civil Appeal number 2159 of 2024. Dhanraj versus Nasir Khan and Others, 2025 INSC 1177. One accident, one fight across life and death, and one law that ensured that justice is never buried. Subscribe for more stories where judgments come alive, because behind every line of law, there's a human story worth telling. Phew, that was intense. If you stuck around for these 10 plus minutes, hit like, subscribe, and drop in the comments. What do you think about adjusting multipliers for actual lifespan? Should more cases factor in real outcomes like this? Next time, another Supreme Court saga. Thanks for watching. Stay curious, stay informed.